Hello everyone, welcome to my channel Beyond Headlines Current Affairs by Lakshmi. As you see, the topic today is Supreme Court DNA Evidence Handling Guidelines. So, these guidelines are issued in the context of Kattavillai alias Devakar versus the state of Tamil Nadu. The case number is 19 of 2013. So, in this case, the convicted has been acquitted due to the lack of proper evidence. And in this context, Supreme Court issued guidelines on various methods of handling guidelines and who are the personnel in charge for that and who is going to take up the whole process. Let us look at it in a detailed manner. First, DNA evidence is a very crucial evidence which makes or breaks a case and which decides whether a convicted person is a suspect is a criminal or not. And in majority of the cases, sometimes the DNA handling is done in a very sloppy way wherein the evidence gets tampered or contaminated and thus it will not provide a proper solid evidence for the case. So in this case, the guidelines that are issued are: number one, though there should be uniformity and scientific vigor in the collection, processing and preserving of the DNA evidence. And most importantly, the sample collection should be done by the staff who are very much experienced, very well versed with the process, and they should wear all the protective gear while collecting the samples. And after the samples are collected, there should be immediate processing of the samples. There cannot be a lapse of time or time lapse in the processing of the samples, because time lapse again makes the sample contaminated. So how the sample should be processed? Sample collection. After the sample collection, the sealing process should be taken up immediately. And once the sample is sealed, the sample should contain the FIR number, the date of collection, the legal sections that are associated with the sample collection, and also the investigation officer, he should oversee this whole process. And there should be the signature of the medical staff that are involved. And there cannot be any lapse in this process. Even if one step is missed, then the evidence will not have the efficiency to be accepted. And next is the transportation. After the collection of sample, transportation of the sample is really important, because the sample may not be viable if the transportation time is very long or if it is not in a sterile condition. So the transportation must be again done within the 48 hours of sample collection, and that too, that sample collection, the sample transportation should be accompanied by the investigating officer. And next, through all this process, the chain of log should be maintained. At nowhere there should be a lapse in documentation. At every stage of transportation, collection, preserving, sealing, everything should be done, and this everything should be recorded and documented, so that at any point of time people can go back and verify at every stage, at every juncture. And samples cannot be opened, altered or resealed without the prior permission of the trial court before the proceedings start. So once it is done without the permission of the trial court, then the sample may not be considered as a proper evidence. That is always there. And next, and all these guidelines address the inconsistencies that are there in the DNA evidence collection, because DNA evidence collection has the direct connection to the suspects, wherein the genetic markers, they have the unique markers, and they link the suspects whether they are convicted, whether they can be convicted, or whether they need not be, can be acquitted. So evidence collection, sampling, processing is a very, very delicate process which should be handled with very meticulous care. These guidelines address the inconsistencies in the evidence collection and enhance the overall quality of the process, like evidence credibility and judicial outcomes, and it strengthens the evidence, and By integrating the scientific precision and judicial safeguards, better quality of judicial outcomes can happen. And now it's time for questions. The first question is, what is the name of the new criminal code that replaced IPC or the Indian Penal Code? Give your answers in the comment section. Next question. What is the name of the new code that replaced Indian Evidence Act? That is the second question. The third question. Who is the Chief Justice of Supreme Court? These three are the questions, and please do give your answers in the comment section. I repeat, the first question is, what is the name of the new criminal code that replaced IPC? The second question is, what is the name of the new code that replaced Indian Evidence Act? And the third one, who is the Chief Justice of Supreme Court? That's all for today. Please like, share and subscribe my channel. Thank you.